Can you avoid probate with a will in place? Can you avoid probate with a will in place? This is a common question many people have when planning their estates. Let's break it down together. Having a will is a key part of estate planning. It outlines your wishes for how your property and assets should be distributed after you pass away. However, simply having a will does not mean your estate will avoid the probate process. Probate is the court-supervised procedure that validates your will, settles any debts, and transfers your property according to your will's instructions. Most wills must go through probate. This means that even if you have a will, your estate will generally be processed by the probate court before your assets can be distributed to your beneficiaries. The probate process can take time, often several months or even longer, and it may involve legal fees. Additionally, the details of your estate become public during this process, which is something many people prefer to avoid. There are some situations where a will may not need to go through probate. For instance, if you have no assets solely in your name at the time of your death, there may be nothing to probate. This can happen if all your assets are held in joint ownership with rights of survivorship, in a trust, or have designated beneficiaries. To avoid probate, you will need to use specific estate planning tools beyond just having a will. One effective method is creating a revocable living trust. By transferring ownership of your assets into a trust while you are still alive, those assets can be distributed to your beneficiaries after your death without going through probate. The trust acts as a separate legal entity that holds your property, and you maintain control over it. Another way to avoid probate is through joint ownership. If you own property or accounts jointly with rights of survivorship, the surviving owner automatically inherits the property when you die, bypassing probate. This applies to real estate, bank accounts, and other assets. Designating beneficiaries on certain accounts is also a practical way to avoid probate. Assets like retirement accounts, life insurance policies, and payable on death bank accounts allow you to name a beneficiary who will receive the funds directly after your death, without court involvement. In summary, while having a will is an important part of estate planning, it does not automatically allow you to avoid probate. Most wills must go through the probate process. To keep your estate out of probate, consider using additional strategies such as trusts, joint ownership, and beneficiary designations. These methods help ensure your loved ones receive their inheritance more efficiently and privately. Understanding the difference between having a will and avoiding probate is essential for effective estate planning.